All right. Thank you very much, Carrie. And hello and thanks everyone for attending today. We got quite a bit of material to cover today, so we want to just dive right in. Last summer, the Supreme Court issued a decision in the main case of Carson v. Makin that set new rules relating to taxpayer funding of private schools, including religious schools. Vermont lawmakers are currently working to revise Vermont's voucher system in response to that decision. The implications of the Supreme Court's decision, as well as the work that legislators are currently engaged in, stand to impact all Vermonters, not just the ones that live in tuitioning towns. So today we're going to try to cover a lot of ground. We'll review the Carson-Makin decision and what it means for Vermont's education system. We'll also consider the Carson case in the context of the Vermont Constitution, and in particular, the provisions regarding compelled support and common benefits. We'll cover the current legislative activity in this area, particularly Senate Bill S66, House Bill H258, and a House Committee Bill, which I understand just got a number today. We'll also briefly cover some of the financial implications of tuitioning and then follow up with a discussion of the importance of public education in a democratic society. After that, we'll leave time to open things up for questions and answers for all of you. And if that's not enough, we received notice just last Friday that the Vermont Supreme Court issued a decision in the Vitale v. Bellows Falls Union High School, where plaintiffs sought the ability to tuition students even if they lived in a district that operated a school. So we'll plan to cover how the Vermont Supreme Court's decision in this case factors into all of this. To get things started today, I wanted to briefly introduce our panelists today. And folks, if your video is turned off when I introduce you, just turn your video on so everybody could get a chance to see you. First up, Harrison, or Harry Stark, is a staff attorney at Vermont ACLU. Harry will help us understand the Carson-Makin case and the implications for Vermont, and also briefly discuss the Vitale case, I believe, right, Harry? Perfect, thank you. Next is Senator Ruth Hardy, senator from the Addison District and the lead sponsor of S66. In addition, Senator Hardy is also chair of the Senate Committee on Government Operations. Next is Edie Granning, is a representative from the Chittenden 3 district and the lead sponsor of H258 in the House. Representative Granning is also a member of the House Committee on Commerce and Economic Development. Next, Peter Conlon is a representative from the Addison 2 district and current chair of the House Education Committee. And I believe, Peter, if I got it right, the committee bill is now H483. Is that correct?
That's what I have been told, yes.
Okay, good that you and I have been told the same thing. So I guess that's good news in that respect. Rebecca Holcomb, who hopefully will be joining us a little bit later, is a representative from the Orange Windsor 2 district and also a member of the House Committee on Appropriations and former Secretary of Education in Vermont. And finally, Peter Burrows is the superintendent of the Addison Central School District and the current president of the Vermont Superintendents Association. Okay, I think I got everybody. And with that, I'm going to turn it over to Harry to get us started on Carson-Makin, that decision and the implication for Vermont. Harry.
Awesome. Thank you so much, Neil. Thanks, Sue, Jeff, and everyone else for putting this together. I really appreciate it. Feel lucky to be up here with so many experts on this topic. I am going to go ahead and share my screen. Great. So I'm going to talk a little bit today, essentially, about how we got here. Questions around constitutional rules with education and the funding of religious programs could fill an entire textbook. And so I don't want to do too deep of a dive today. Although there's a lot of nuance and I think can play in the joints, what I want folks to be able to come away from today is just understanding the sort of broad strokes, or essentially the moves that the Supreme Court has made, and how they've interacted with the way that education has traditionally been set up in Vermont. And although there are, a number of, I think, sort of nuances or open questions in some of the recesses here, hopefully the broad strokes are straightforward enough that folks can come away feeling like they understand essentially the kind of key steps into how we got here. And so at a very high level, I just want to start out by talking about the Vermont Constitution. And sort of what does the Vermont Constitution say about education? There are two really key components here. One is the Education Clause, which creates the constitutional duty for the legislator to operate a competent number of schools throughout the state. Essentially, that's the origin of the right of education. And the way that we think about education as a public good comes from this constitutional provision. The second part is something called the Common Benefits Clause, which you may have heard about, which says that government has to be for the common benefit, protection, security of the people or the community, and not for any sort of particular group of folks within the community. It's essentially a provision that says government has to be for everyone on more or less equal terms. And famously, the Vermont Supreme Court read these two provisions together in a case called Brigham, which invalidated the way that education had previously been funded, essentially a purely town by town basis. And what Brigham said is, sort of reading these twin constitutional provisions together, what the right of education looks like in Vermont is that the state has to ensure substantial equality of educational opportunity. Brigham is the reason that we have the pupil weighting formula and a number of other provisions, and essentially says that although there can be some variations, essentially every Vermonter, every student in the state has to have a substantially equal opportunity to an adequate education. Until very, very recently, Brigham was essentially all that the Vermont Supreme Court had said about the right to education and the way that it must be provisioned on equal terms. You heard a little bit about Vitale, which is an opinion that came down on Friday. I'll talk a little bit about Vitale towards the end of my presentation, but Vitale was essentially a case brought by a number of parents, which alleged under Brigham that the fact that some towns were tuitioning towns, that they had the opportunities for parents to choose a school for their child to attend, and some towns didn't, that differentiation in choice was a problem under the Common Benefits Clause, and that parents essentially had a right to school choice under the Vermont Constitution. The trial court rejected that complaint at the threshold stage. It said it failed to state a claim. And on Friday, just this past Friday, the Vermont Supreme Court affirmed. And there's a little bit of a dense quote here, but essentially what the court said is the Education Clause requires that the state provide an adequate public education, and the Common Benefits Clause requires that the state provide that on substantially equal opportunity terms. But beyond that, there's really nothing in the Constitution that mandates one way of doing that versus the other. And it's certainly not right, the court said, to think about school choice as a right that is on par with the right to education more broadly, or the right to substantially equal educational opportunity. And that essentially school choice is a permissible means the legislature has historically chosen for providing equal education, but it's by no means a required one. And so the court made really, really clear that sort of what matters under the Vermont Constitution is that the state is providing public education and that it's doing so on substantially equal terms for every student. And how the state goes about that, whether it's tuitioning or something else, is really a matter of legislative grace. There's also another part of the Vermont Constitution, which you may have heard about, which is the Compelled Support Clause. That's Chapter 1, Article 3. Essentially, the Compelled Support Clause is a provision that says every Vermonter has the right not to support religious worship or if it disagrees with their individual conscience. And traditionally, that has been thought of as an individual right that prevents forced subsidization of religious programming. And again, in the context of education, the leading case that the Vermont Supreme Court confronted this was a case called Chittendentown. And what Chittendentown said is that when districts reimburse tuition for a religious school without adequate safeguards against the use of public money for religious worship, that's a problem under the Compelled Support Clause. And because of that, it's a decision that came down in 1999. The prevailing practice, as you all know, of the state board and the Secretary of Education was that essentially religious schools were just not eligible to receive tuition funding. And that was the sort of way that the state had implemented the requirement of adequate safeguards. Now, all of this case law in Vermont has stayed relatively stable. The meaning of the compelled support clause and the meaning of the education clause has not changed very much over time. In contrast to that, the US Supreme Court has been radically changing the way that the First Amendment interacts with different components of state constitutions and the federal constitution. And the real shift is in the way that the free exercise clause interacts with the establishment clause. And again, I'm just going to go over this in very, very broad strokes here. So that, folks may remember this from civics, or if there are any lawyers in the room, they'll remember this from con law. The First Amendment contains something called the Establishment Clause, which says that the government shall not establish a religion. This is the origin of the ideas of separation in church and state, and has historically been understood to prohibit government entanglement with religion. Although the clause's contours have changed over time, the Supreme Court had at least understood the Establishment Clause to allow for states to be extra cautious, in a sense, about commingling government functions with religion. Separately, the First Amendment also contains the Free Exercise Clause, which protects an individual's right to practice their religion, essentially free from government intrusion. It's an anti-discrimination clause at its core, and it prevents government from discriminating against either religious persons, religious practice, or any particular religion. And kind of the canonical case here, which I think sort of illustrates the way that folks had traditionally thought about the Free Exercise Clause, is a case called the Church of Lukumi Bablu I. And what that case was about was a church practicing the Afro-Caribbean religion of Santeria, which uses animal sacrifice as a form of worship, announced it would open up a church in Florida. And almost immediately, the town enacted an ordinance banning animal sacrifice or slaughter. Supreme Court said that violates the Free Exercise Clause because the town in Florida, you essentially did this in order to target and discriminate against this particular religious practice. And essentially the move that the Supreme Court has been making and the arc of the past few years is that the newly constituted US Supreme Court has been viewing essentially preferences that were traditionally allowed under the Establishment Clause, preferences for secular government services, have been viewing that as a form of discrimination against religion generally. And so I want to talk about three cases which have sort of laid the groundwork and done the various moves over the last couple of years that have sort of gotten us to where we are. So as I said, sort of historically, the court was skeptical of funding of public funds flowing to private religious institutions. The court loosened some of those requirements in the early 2000s to say that the Establishment Clause permits a state to allow parents to choose a religious school when using things like a public voucher. The essential logic of those cases is that there's no government entanglement with religion when it's parents or sort of private institutions choosing to send their money to religious actors. But those cases in no way mandated the subsidization of religious entities, religious instruction. It was always thought that there's not an Establishment Clause problem if a state wants to do that, but if a state wants to be particularly cautious and ensure that the provision of certain government services are fully secular, that's absolutely fine as well. And in 2017, the court decided a case called Trinity Lutheran Church v. Comer. And this is about Missouri operated essentially a funding program for playground resurfacing. But under that program, any religious organization was automatically excluded by virtue of just being a religious organization. And the state had rejected a grant application from a church purely on the basis that it was a church. The Supreme Court reversed that, said 7-2, and said that the Free Exercise Clause prohibited Missouri from excluding a recipient purely due to its status as religion. And as the sort of 7-2 lineup reflects, this result was not considered to be hugely controversial at the time. The essential logic of the opinion was that playground equipment really has nothing to do with religion, and it's otherwise kind of available to everyone. And so to single out a religious institution for worse treatment than everybody else for kind of no other reason other than the fact that it's a religious entity is a form of discrimination. There was famously a footnote in this case that said, what we're talking about here is just playground resurfacing. We're not making any wider pronouncements about how the free exercise clause interacts with the establishment clause or anything like that. But as the 7-2 lineup reflected, this was the application of fairly uncontroversial settled principles around religious discrimination in a narrow new context. But the court radically expanded the sort of core principles of Trinity Lutheran in a case called Espinoza in 2020. And Espinoza concerned a provision of the Montana Constitution that said essentially public money cannot go to subsidize religious entities or religious schools. And the Supreme Court held that even though the Montana Constitution said that, it violated the federal free exercise clause to exclude private religious schools from their voucher program due to their religious status, even if the Montana Constitution required that. And the court was clear that a state has no obligation to fund private schools, but once it chooses to do so, it cannot exclude participants based on their religiosity. As I mentioned a couple minutes ago, Vermont's prevailing practice had been to exclude religious schools from tuitioning just as a category. Espinoza, when it came down in 2020, immediately spelled trouble for that practice and spawned a series of lawsuits that sued the state of Vermont for that practice. I think key to Espinoza in 2020 was this idea about religious status. It said Montana couldn't exclude religious institutions simply because they were religious, but it left open this question about whether or not states could restrict funding based on religious use. That is, not who a funding recipient was, but what a funding recipient planned to do with the money. And the court answered that open question just this past summer in Carson v. Makin. Sorry, I'm going to go back here. And Carson v. Makin really applied Espinoza in a more radical and expansive way. So Maine had said that what it was offering was not just a voucher program to sort of any independent school. The benefit that Maine said it was offering was, in its words, the quote equivalent of a public education. And Maine laid out a number of requirements that they thought sort of amounted to a public education. One of those requirements is that the school was secular, as all public schools are required to be. The Supreme Court said that this requirement too violated the free exercise clause. And although the court claimed it was just really applying Espinoza from 2020, the opinion's logic, I think, is really important. So unlike Montana, which had categorically excluded religious schools from the benefit of tuition, as I said, Maine tried really hard to say, we're not offering tuition generally, we're offering a public education. The court rejected this, saying, Maine, no, you're not offering free public secular education. What you're offering is really tuition. And because you're allowing tuition to flow to a lot of schools that in many other ways are not like public schools, and that they can charge admission, they can choose their students, they may not have to comply with particular curricular requirements. The way that you're differentiating between schools is on the basis, in part, on religion, and you can't do that. You can't exclude any school for anything that has to do essentially with their religious character or activity. Alternatively, Maine had said, well, we're not excluding schools because of their religious status. We're placing a use-based restriction on these funds. We're saying that a school cannot use public funds in order to engage in religious instruction. And the court answered the question that it had left open in Espinoza and said, it's not just about religious status, it's also about religious use. Any form of restriction on funding that essentially targets religion, whether it's religious status or religious use, is a form of presumptively unconstitutional discrimination under the free exercise clause. And so this is essentially one of the core holdings Carson v. Makin, is that the Chief Justice reiterated that a state need not subsidize private education, but as soon as it does so, it cannot disqualify some private schools. Sorry, I have a cat here who's clearly very invested. You cannot disqualify some private schools solely because they are religious. In the wake of Carson v. Makin, the state ended up settling a number of the challenges that had come since Espinoza that were challenging Vermont's prior practice of excluding religious schools based on their religious status. And as part of that settlement, the Secretary of Education issued a guidance to schools, which I imagine many of you are familiar with, that said schools can no longer rely on the adequate safeguards test, which had been the prevailing practice since Chittenden Town in 1999. And that has been essentially the status quo in September. I just want to close really briefly by just returning to Vitale and this opinion that came out on Friday, which I think kind of clarified the stakes of some of the things that we're talking about, which is Carson v. Makin, yes, I think radically upended ways that many states had thought about the relationship between free exercise, the Establishment Clause, and public education. But what it really did, I think, in some ways, is sort of clarify many of the rules that we're dealing with and set really clear guideposts for what states are and aren't allowed to do. And I partially read what the Supreme Court of Vermont was talking about in Vitale as, again, sort of clarifying the stakes of this debate in a certain way. And so the Vitale court, I think, is very clear that when we're talking about the right to education and the values that are most dear to Vermonters, school choice is really just a means to an end. It's a way of effectuating the constitutional guarantee of public education that provides substantially equal opportunity. And what really matters is that this is a common benefit that should be available to all Vermonters, regardless of geography, regardless of race, regardless of gender, regardless of status. And that's the right that the Vermont Constitution protects. And although school choice has been a permissible way to do that, there's nothing written into the Vermont Constitution that requires states, that the state to essentially choose that path. I'll stop there and turn it over to some of the other presenters.
Thank you very much for that, Harry. Great background then for attendees to understand sort of the context that we're in. And with that, I do want to turn it over to, I'm going to turn it over to Senator Hardy, just to describe S66, and that path forward for Vermont as legislators we're considering, the possible path forward here. Senator Hardy.
Great. Thank you, Neil, and thank you, Harry, for that really good overview of the landscape that we find ourselves in. I, unlike Harry, do not have a lovely slideshow for you. I'm an overextended state legislator, so I will just provide you with a summary of the bill that I introduced earlier this session, which, by the way, was co-sponsored by 10 other senators. More than a third of the Senate is a co-sponsor of this bill. And S66 is really a reaction to the kind of tumultuous landscape that we find ourselves in, given the recent Supreme Court cases, both at the state and the federal level. And what it does is it provides a definition for schools that can be designated to receive public funding under the law. And it's based on the current designation statute, and says that only public schools can be designated to receive public funds, and schools that meet 3 of a 4-part test that would define them as eligible for designation under this this bill, and that they are, in addition to public schools, an independent school that meets one of these 3 of these 4 criteria. They are a recognized independent school that serves as a regional career and technical education center, a recognized independent school that was established through gaining a charter by the Vermont General Assembly or the Vermont Legislature, recognized as a qualified public school in state statute as of June 30th, 1991, or a recognized independent school whose employers, an employer of teachers that are in the state teacher retirement system. So essentially that 4-part test includes the 4 historic academies that have for many, many years, over 100 years, been well established to be sort of part of our public school system in Vermont. So that's the first criteria, and only designated schools would be able to receive public funding under the tenets of S66. Most of you are familiar with what are called therapeutic schools, and these are schools that public schools often send students to receive high-end complex special education services. The ability to send students to therapeutic schools for such services is preserved under S66. It must be done in a way where these are services that cannot be provided by a public school. So if the public school can provide those services would be provided in a public school. If they are such specialized special education services that they would need to be done through a therapeutic school, those services could be provided through a contracting relationship, not a tuition relationship, but a contracting relationship with the therapeutic schools. Private schools would no longer be approved for public funding. The concept of an approved independent school would no longer exist under the provisions of S66. But the bill would maintain what are now considered recognized independent schools. And those are schools that meet the basic health and safety and curricular standards to ensure that students who go to those schools would be receiving a basic education and be in a safe and healthy atmosphere. There is a transition period. This is not expected to take place overnight, but there would be a 5-year transition so that school districts and families and students would be able to prepare for this change in the statutes. So the basics of S66 are really that public funding would be provided to public schools in the state, and in large part as an answer to the complexity that Harry set out regarding the use of public dollars for education in Vermont. So that's a basic overview. It has not been taken up in the Senate. As you heard, this has really been an issue that started its conversation in the House. And I do want to recognize my colleague, Representative Edie Granning, who herself is also a school board member, who is the House lead sponsor of a companion bill to S66, which is H258, I believe, in the House. And so I will just turn it over to Edie if she has any further comments about the bill.
Thanks, Ruth, and thanks, Neil, for putting all of this together. I don't have anything specific to add about the bill, Ruth. I think you did a phenomenal job of explaining it. I will say that we had, I believe, 37 co-sponsors, 36 or 37 co-sponsors in the House, and we only had 24 hours with the bill. We were trying to get it from final writing into the committee as quickly as we could, so they'd have time to take it up. So that was really a big response in not a lot of time. And we've had a lot of really interesting conversations and deep conversations about it. I think, Neil, at this point, you want to talk about what's really happening today in the House, right? So I'll turn it over to you, unless there's something specific you want me to say.
No, I think that covers it for the moment, but certainly hope that everybody can stick around, because I do imagine we'll get some questions at the end of the webinar that you folks could help us answer. But with that, I would like to turn it over to Representative Conlin. If you could just walk us through the current status of things, particularly surrounding the committee bill that's being considered at the moment.
Yeah, great. Thank you. I'm Peter Conlin from Cornwall, Vermont, chair of the House Education Committee. The committee has been working on a bill, and let me just say at the outset that the Carson v. Makin decision prompted our work, but it definitely doesn't solve the constitutional issues that are at play here. What it really, for us, prompted was a kind of a look that hadn't been taken of our town tuition program, at least certainly in the 7 years that I've been in the House Education Committee. And so it was, we essentially started taking a lot of testimony, in reaction to the decision and to sort of what are we going to do with it. But taking as big a step as H258 and S66 anticipated, with a new committee in the first half of the first biennium, first half of the first year of a new biennium, seemed a little bit too big a bite to take. But what we did discover was a lot of things that really could be tightened up, sort of corrected, and sort of have our system better reflect what we consider to be the values of Vermont. So we have a committee bill, which is now H483, will be on notice this week, and first reading will be on Thursday, or second reading will be on Thursday. Essentially, it lists a bunch of provisions that are going to be required if you want to continue to be an independent school eligible to receive public tuition. That begins, of course, with Act 173, all of the special education provisions that are in there that were already known and were going to happen. But it basically says that, an independent school must enroll any student who requires special services if the local education agency, the school district, feels that that is the least restrictive environment for that student. In addition to that, we add other conditions to be an approved independent school eligible to receive public dollars. These are things as small as reporting enrollment changes in a student, whether they've been suspended, withdrawn, expelled. We also have reporting on attendance in general in a better way. And this was really the result of taking testimony from superintendents who said, we send these kids off, we don't necessarily get regular information on them. We also have a reporting requirement for annual progress on students. And then we get into the bigger things, like the school will have had to adopt policies that comply with the Vermont Public Accommodations Act and the Vermont Fair Employment Practices Act. The big one, which was really sort of codified on Friday, so it's sort of late breaking and people are trying to figure out exactly what it means. But we basically said that you can't use required interviews, entrance exams, academic history, required visits, or consideration of ability to pay fees in an admission or an acceptance, let's say, of a publicly tuition student. The overriding philosophy here is to say, if you want to accept public dollars, you don't get to pick and choose which of those kids are going to attend your school. That is what that basically says. We'll probably be adding some more things to make sure that that's also true of public schools accepting public dollar students, which in practice it is, but it's a little bit fuzzy in the law. It also has requirements that all state required assessments that are given to public dollar students be shared with the local school district as well as with the Agency of Education, and their job will be to come up with a way to put that information together and put it on their website, just like public schools have to do. Provision that says that if you charge tuition, a public dollar tuition, that tuition can't be any higher than what you charge a private pay tuition paying student. And then we have essentially creating a form that would be an annual attestation to complying with all of the policies that I just spoke about, most importantly, the VPAA and the Fair Employment Practices Act, but as well as the other issues. Probably two other things to talk about. It also proposes a moratorium on any newly approved independent schools eligible to receive public dollars. And it also sets a 25-mile border around Vermont so that money can only go to states that border Vermont and only within 25 miles. Again, to reflect the value that this program, the town tuition program, despite its age, was never meant to be a subsidy to send your child away to boarding school. And it was also never meant to be a growth industry, hence the moratorium. I mean, those are the main provisions. Be happy to take any questions at the end. And I should just say that it was voted out of committee on a party vote, essentially 7-4-1. We had one member missing who would have voted for it, so it would have been an 8-4 vote.
All right, thank you, because I was going to ask you what the status of the of the bill there was. So you beat me to it. And then Representative Collin, just status of 258 then.
We're in the first half of a 2-year biennium, so it remains resting comfortably on the wall.
Okay, thank you very much.
And I guess I will say that, I'm a bit of a pragmatist. I tend to believe in the art of the possible. And I would say that sort of given the political reality and landscape that we have, both in the State House and in the governor's office, the other two bills would have been a challenge to get to a final law.
Thank you for that. So I do see we've got some questions that are starting to accumulate in the Q&A. I encourage folks to continue to drop those in there as you think of them. But we're going to move on in the presentation. We'll save the Q&As for the end for all of our panelists. But the next thing that I want to do, I'm going to share my screen just to briefly go over some of the financing implications of tuitioning in Vermont. For those of you that have seen, I've done a couple of videos. One was on the history of tuitioning in Vermont, and a second one covered some of the financial implications of tuitioning or our voucher system. I've condensed that second one down into 6 points that I just wanted to cover briefly today, just to hit sort of the highlights for folks in case you haven't seen the other videos. The first item that I want to cover is the education fund, or the Vermont Education Fund. That education fund covers all pre-K through 12 education spending in Vermont. This includes both public schools and private schools that are funded with public dollars, or what we commonly know as the tuitioning towns in Vermont. Those school districts that don't operate one or more grades and are able to use public dollars to send their students to other public or private schools, both within and without the state at the moment. While most Vermonters know that their homestead property tax funds the education fund, it's also important to note that the education fund also receives revenue from the non-homestead property tax and all of the sales and use tax. Those are the sort of the three primary funding sources for the education fund. You'll see that there are a bunch of other smaller ones in there as well, but those are the main ones. The second item, number 2, the thing to understand here is that while local school districts determine education spending, it's the state's responsibility to raise that money. By setting the property yield number, hopefully, which is a number that is familiar to most superintendents and board members, that is a number that impacts every school district in the entire state. It's set by the legislature at the end of the session, but it's to ensure that the state can raise enough money to fund all voter-approved budgets in the state. Which brings us then to number 3. So what this means then is that your local tax rate depends not just on what you spend, but also what school districts all across the state spend on education. Which brings us then to number 4. So when a portion of Vermont's students take their public education dollars to private schools, the impact is felt by all taxpayers in Vermont. And this is due to a couple of factors. Private school tuition is based on the average cost per pupil in Vermont public schools. And that cost has been increasing significantly over the last 8 years. Since 2016, secondary average announced tuition has increased by just over 20%, and elementary average announced tuition has increased by just over 30%. There are a few factors behind that increase. One is our state's declining enrollment. Another is that when students take those public dollars to a private school, that is a loss of revenue for the public school. And that local school board then has a tough decision to make. That they could either cut programming, staff, or other areas of the budget to make up for the loss of the money, or they could maintain those items and increase per pupil spending. But there are also some exceptions to that tuition rate. Some schools are allowed to charge more than the average announced tuition. They're allowed to charge their own rate if the school meets or assures that it will substantially comply with education quality standards, if the school is considered a state-approved public school as the result of designation, or if the school operates a career or technical center, or if the electorate in the community votes to pay a higher tuition amount. Private schools, as Peter had noted before in some of the work that they're doing on the committee bill, private schools currently have selective enrollment practices. This results in public schools disproportionately serving student populations with greater needs and at an increased cost. Data from the Agency of Education bears this out. We see that students that are eligible for free and reduced lunch and students with disabilities are disproportionately served by the public schools versus the private schools. And then finally, point number 6, increased tuition costs have forced some districts to cut back on spending for grades that they operate. This was true back in 2015 when school districts across the state, I'm sure a lot of you remember, were struggling to craft budgets that fell below the excess spending threshold. At the time, Vermont Digger reported that school boards in Linden met with the heads of both the Linden Institute and St. Johnsbury Academy to implore them to keep any tuition increases as low as possible. In that same VT Digger article, the chair of the Linden Town School Board noted that each $800 increase in tuition per high school student would result in a $510 decrease in what could be spent at the K-8 level. That was a quick walkthrough of sort of the 6 main points that our financing system has on what school boards all across the state are dealing with at the moment. But I hope it gives you a little bit of insight. I know that we're running a little bit ahead of schedule because I think we were still waiting for Representative Holcomb to arrive. But I wonder if I could turn it over now to Peter Burrows. Are you prepared to discuss a little bit about public education and our democratic society?
Yep. Happy to. So hi, everyone. Peter Burrows. I'm superintendent in Addison Central, and I am currently VSA president. I think the speakers that have spoke already have covered this issue really well, especially thinking about the impact of where this could lead as we look at what we've created and what our values are as a state in looking at the needs of our students. I first, started hearing about this issue, not in Vermont, actually, but nationally. So I'm one of the 2 delegates for the Superintendents Association as part of AASA, which is the National Superintendent Association. Those of you who are following this issue know that this is a huge national issue. The AASA organization, starting about 5 years ago, really started to lean in at our national conference on education and started talking about the impacts of privatization in different states. And there's plenty of research out there that does articulate what happens to public systems when people start, essentially getting a voucher and it becomes kind of more of a free market enterprise. In my experience and talking to some of these superintendents in other states and hearing about the impacts, it made me feel kind of grave concern for the work that's happening here right now, but also I think one of the things that as Vermonters that we hear a lot about is choice, and this idea that in a democratic society, it makes sense for people to be able to choose for themselves. And in terms of what happens for students and what happens to school systems when everybody has choice, those that can navigate the system, those that understand, those usually of means, are able to navigate the system in a way that benefits them. And those that aren't able to navigate the system end up at a disadvantage. And the whole purpose behind having a public education system is to raise up all students, not to raise up some and hope that the other ones do well. And if my I think all of our concern right now is that if we allow choice to blossom, many of the systems that we have created and supported will no longer have the ability to do the work that we need to do from an equity perspective to meet the needs of all students. I think in any strong democracy, and one of the things that came to mind for me as I was thinking about my own experiences as an educator in terms of democracy and education, I spent about 10 years teaching overseas after graduating from university. And one of the things that struck me in some of the countries that I lived in was the fact that in places where there was more privatization, the class distinctions were much greater. That there wasn't a sense of we're in this together. There was very much those that could play the system and those that couldn't. And I think if we as a state, and I think as a country, and kind of in a broader way, let go of public education, and there are many forces that are pushing this, it's going to be hard to take back, and it's going to create significant division, and it's going to make it so that we're not able to help those students who need the most. I think a few people today have talked about schools that are publicly funded also sustain the values of the people within those communities. And I think if you talk to people in our communities, I know in this community, when all is said and done, our community really, really supports meeting the needs of every student. And I think that is critical. I think something needs to happen here. I don't think we can wait and see what happens. I think the work that's happening in the legislature, frankly, is really, really strong. And I say this on behalf of all superintendents. I think we're watching this intently and realize that the outcome of this is going to have implications for decades to come.
Thank you very much, Peter. I appreciate it. So folks, we are still waiting for Representative Holcomb to be able to attend. I think she was wrapped up in her own committee meeting. But why don't we take the opportunity, I think, now to switch over to the Q&A portion of things. And then once Representative Holcomb arrives, we can provide her a moment with everyone. So Carrie, maybe you can help me out a little bit. I am looking through the Q&A so I can see what folks have submitted. Couple of questions I think that are related to either H258 or S66, as well as the committee bill. First one is, could we get examples of private or non-religious schools that would be affected by the bills? Some of the examples are Long Trail, Killington Mountain School, or the other mountain schools. I'm guessing that the answer to that question is different between 258 and 66 versus the committee bill, but I don't know if Senator Hardy, Representative Grang, Representative Conlon, if you might be able to offer some response there.
Yeah, I'd be happy to go first. I guess I would quickly say that the committee bill shouldn't affect them, assuming that they choose to have a system that is non-discriminatory in both their students who are there and in their admission process and in their hiring process. I think that what we have in sort of the list of conditions that we have in the committee bill are, in many cases, especially with the larger schools, are conditions that they're already meeting. And even some smaller schools have basically told us, we have open enrollment. We don't discriminate in any way.
So if S66 and H258, which are the same bill essentially, with just different numbers, though they would impact all independent schools the same, in that there would no independent schools would be eligible for public funding. So every school would be treated the same. The one small kind of window is for the historic academies, which would be included as part of the public school mix because of their historic sort of place in our public education system and meeting the 3 of the 4 criteria exposed or outlined in the bill. So every independent school, regardless of area or type of school, would be otherwise treated the same.
Thanks. And we've got a related question to that, and it concerns Northeast Kingdom and the option of selecting a school in Canada. Was that either provided in either of the bills?
In S66, public schools in other states would be allowed to be designated, such as, for example, that I know that there are communities that send kids to the Hanover High School, which is a public high school in New Hampshire. It doesn't specifically address Canadian schools in the bill. Frankly, that didn't come up when we were drafting it. So it doesn't address them at this point.
I could almost say ditto in that it didn't come up in our discussion. And we will be taking up a conversation about whether to include within that 25-mile radius Canadian schools as part of a committee amendment. So
Thanks.
It was not necessarily intentional to leave them out. I think there was a concern about the ability to enforce non-discrimination in a foreign country, which is what made us hesitate.
Thanks. I've got one here that might be good for Harry. The question is, any thoughts on how Carson interacts with Our Lady of Guadalupe versus Morrissey Baru, which found that religious school teachers are actually religious ministers?
Sure, that's a great question. I think the best way to answer that is that it doesn't interact directly. I think it's actually important to highlight the ways in which they don't interact at all. So Our Lady of Guadalupe v. Morrissey Baru was a case about the so-called ministerial exception. I see that Representative Holcomb has signed in here, so I'm happy to answer this quickly and then yield the floor. The ministerial exception basically says that laws that would regulate a private business or a secular association can't apply in the same way when they're dealing with the internal management or operations of a religious institution. And what the court said in a series of cases, but most recently in Our Lady of Guadalupe, is that teachers who are tasked within a religious structure for essentially propagating the religion and training the next generation can qualify as ministers within that exception. And where the ministerial exception applies, there can be some wrinkles and some difficulties with applying certain types of anti-discrimination law, like employment law. But I think what's really important is that there is no case that suggests that there's any problem at all to requiring full compliance with anti-discrimination laws in the context of students. And so the sort of the value, the First Amendment value that the court is trying to protect in those ministerial exception cases is really preserving the internal management structure in some ways, or sort of the internal governance and direction of religious institutions, which are just not implicated when it comes to things like admission or discrimination of services that are available to the general public. And so I've seen some suggestions somewhere that there might be problems with applying the Vermont Public Accommodations Act for students at religious schools. I just don't think that that's the case. The court is clear that so long as a law is neutral and generally applicable, that means it applies to everyone the same. You don't have exceptions for certain groups or certain people, but it applies across the board evenly. There's no problem, even if that does incidentally burden religious exercise. And so I hope that answers the question, but it doesn't directly implicate it. But I think one really important way to see where it doesn't is in the provision of services to students.
Thanks very much. Representative Holcomb, thank you so much for being able to join us. We are moving right along. We're having a great discussion this afternoon. We jumped into Q&A just briefly as we were awaiting your arrival, but I did want to give you an opportunity. Peter Burrows just had a chance to talk about the importance of public education in a democratic society, and I believe that we had sort of tasked you for some comments and some insight on that topic as well too, or anything else that you want to share with us on this issue.
Right. Well, thank you. First of all, I am so sorry. I hate coming in late because I didn't hear what came before. And I feel like that's an important part of a conversation. I would be remiss if I didn't start, first of all, by thanking everybody who's on this call. You are part of one of the last big and truly democratic institutions in the nation. We know our public education system is how we work together in our communities to make sure every one of our children has a fair chance, no matter who they are or where they come from. And I know some of the people on this call have been around since Act 60. I remember working with Alan Avery, a former Republican senator, in a different time, and we had formed Rivendell, a unified public school system. And I remember one of the people speaking against that decision said doing so and building a new building to house it was like dressing up a tramp in a top hat. And I share that just to remind us that there are many people who don't think some of our kids are worth it. And that was a time I was so proud to be part of Vermont education and working for people who genuinely believe that every child, no matter who they were, was our child and our responsibility. And I remember being so proud of a state that was willing to work together and have people in various communities give to make sure that we put the wealth of the state behind every child. I think you've had other panelists earlier who can speak so powerfully about how we got to this moment. Certainly when I was secretary, these people were already suing us. In fact, they've been suing us for decades. We can debate how or whether to regulate private schools whose business model is based on public taxation and who talk about closing public schools as gaining market share, which I have heard. But if you take one thing away from this conversation, I think it should be this. What we do now in this moment will define who we are, and it will affect all of us, no matter where we live and whether we're in a district that operates public schools or does not. The Supreme Court said that no state has to fund private education, but if it does, it cannot treat any private school differently from another, whether it's a secular school or a religious school. We also have a constitutional obligation that prevents compelled support of religion, and choosing to ignore that is trampling on the constitutional rights of some Vermonters. Beyond that, we know this system is segregating. The only time we've had available public data, what it showed us is that in tuition towns, well, about 50% of students from tuition voucher towns attend public schools, about 60% of students who are eligible for free and reduced lunch, and about 70% of students with disabilities from those towns attended public schools. That is concentration of disadvantage, and it has profound consequences for equity of opportunity in our states. And it isn't to say that our public schools are perfect. No one on this call would say that. What is different about public education is that it is transparent, that there exists a right of due process, and that we are accountable to voters. I remember at town meeting in Fairleigh being asked by a voter on the floor how much we spent on pencils. That is how we can hold ourselves accountable to making sure that we're being fair to all kids. I think everybody on this call and everybody who cares about equity of opportunity owes a huge debt to the House Education Committee. I didn't hear the whatever was said earlier, but I think we saw more progress in committee last week than I've seen in my 8 years in working at the state level in education. What they did was put on the table some of the mechanisms by which this segregation happens. We can't make progress until we see what we're dealing with. So I'm feeling huge gratitude to House Education for the work it's done to try to challenge us all to understand better what our current situation is. And as we've all read in the recent headlines, and I think you've been talking about for the last hour, there are other issues that we have to grapple with. As one of my constituents asked me at town meeting, why are we forcing her to pay more taxes to fund homophobia? It's something she characterized as state-funded bullying. And this matters because this segregation leaves us poorly prepared for life in an increasingly diverse and pluralistic future. We cannot learn to work together with our neighbors if we can't even agree to sit in the same classroom with them. And we can hardly be surprised when school board members and even legislators in 10 years say discriminatory things if this year we have paid to teach them those things in school. The impact is also financial, not just for the towns that pay tuition, but for all towns. We spent years encouraging schools to unify so that they could put their resources together and put more dollars directly into kids and less into overhead. And at the same time, we are now picking up an entirely new group of schools that divert the impact of those shared precious public education dollars. I had a school board member from a town that pays tuition who came up to me a couple of months ago, and she talked about how hard it was for her district, which pays tuition, including to religious schools in New Hampshire, where the Public Accommodations Acts don't provide protections to transgender students. And she said she was in a hard position because they couldn't decide which of a total of 4 private schools they wanted to tuition to, that they would cut down to 3. But here's the thing, her inability to make a choice means people like me and people like the constituent who wrote me have absolutely no choice in whether or not our dollars are used to support things that really feel fundamentally antithetical to Vermont values, and which ensure that some kids are handed a list of different schools than their neighbor's child is handed as possible options at that level. And we all have to fund this. But most of all, this is about democracy and about whether or not we can work together as a state and as communities and find common cause with our neighbors in creating a bright future for our kids. And I don't know any other institution in Vermont where, as I think back to my days in Fairleigh, somebody who was the biggest taxpayer in the district sent their child to sit next door to somebody who had no running water in the winter. This is where we learn, and this is where we build common cause with our neighbors. A.O. Hirschman once wrote a book called Exit, Voice, and Loyalty, which is about the rise and fall of institutions and what makes them strong and what makes them erode and fade away. And the challenge of having the option of exit, of choosing to opt out on your neighbors, is that you take your energy and you take your dollars away from creating institutions that are among the most powerful engines of opportunity. In Vermont, we actually use public education to fund economic development, to keep our farms vibrant, to provide basic health services to kids. We can't erode that institution and expect it to deliver on the promises and the hopes of our people. Alternatively, what makes them strong is when people use their voice and exercise loyalty, when they stay with it because they believe in democratic institutions, they believe in pluralism, and they believe that we actually can't have a bright future unless we're willing to hash it out, as imperfect as the process feels, to figure out how to work together, to live together, and to raise our children together. So I don't want to talk too long. I'm obviously very powerful about this. I'm going to close again by expressing deep gratitude to House Education for moving this conversation. I think we all have hopes for what comes next, but I just have such gratitude to them for getting this conversation started. So thank you.
Thank you very much, Representative Holcomb. I'm going to move back into Q&A and we'll try to pop around and see if we can get to as many of these as possible. One of the ones, it might be a good segue from some of the points that Representative Holcomb just brought up. The question is this proposed legislation to ban, restrict public funding for religious schools really that big of a problem? Rice and MSJ don't seem so radical to me, at least no more so than BBA and St. Johnsbury, which have already been carved out. Or is your concern more of setting a precedent for public dollars to travel anywhere outside the state with no oversight?
I can take that one if you want. I haven't said a
Sure.
whole lot yet. And my concern is that we need to understand how public dollars are used. We need to understand what kinds of education students are actually getting in their classrooms. And we need to be able to ensure that all students have equal opportunity. That's my main focus here. I think Carson versus Makin kind of brought it to the forefront. And if we continue down the path that we're on, I have real concerns about how education, shouldn't say it that way, I should say if we can fund education in Vermont, because funding these two systems, two separate inequitable systems, doesn't have longevity at all. So.
Thank you.
Neil, I can add. I mean, there are people on
Please.
this call who are far more expert than me. I think there's two issues here. One is I think the issue of out of state is different. I think the risk there is that Vermont has some of the most comprehensive set of protections for people in terms of our anti-discrimination statutes in the country, and that when we tuition out of state, we are setting up a different standard for people who tuition in state and out state. They do not have the same protections. I think that's one of the challenges there. With respect to the issue of Rice and MSJ, I would defer to the folks who specialize in this, but I think the challenge is that Vermont's Constitution says that you can't, we can't obligate people to fund expressions of conscience. I will stay out of names, but many of the schools that we talk about are ones that are quite transparent on their websites about faith being infused into every aspect of life and education at the school. And as my local pastor said, you know, I don't really want you monkeying around in my church, but I also don't want to be monkeying around in your government. And I think the challenge is when you begin to talk about how you regulate, I actually don't know why a religious school would want hopeless entanglement of the government in verifying whether or not they're practicing religion or not. And I'm not even sure they could. I just think this is, I'm going to defer to the ACLU, but I think this is a constitutional issue.
Thank you for that. Another somewhat related question, I'm paraphrasing here. Regardless of what the legislature does or attempts to do in this session, are we just looking at a bunch more future lawsuits related to this? Harry, do you have a crystal ball on that one?
I mean, what I will say is I think that there's an important distinction to draw between the threat of being sued and the threat of being sued and having a statute invalidated. I think we've seen there's a lot of political mobilization around these issues, whether it's religious schools, whether it's school choice, whether it's in-state versus out-of-state. There's a lot of investment in these issues, and litigation has been a powerful tool in those movements. And so I think I'm sorry to say that regardless of the path that the state chooses, it's guaranteed that there's going to be litigation. I think that the goal should not be trying to avoid a lawsuit, because I think their lawsuits will be filed either way. The question is, how meritorious are those lawsuits? And the goal should be to create a system that serves Vermont's values and will pass judicial review. And so I think thinking about, what are ways that we can construct a system and incentives and a political economy of education that really serves our values and serves all Vermonters, but complies with these very real legal limitations. That that should be the goal. And, I know that there are folks who are working hard at that in the Ledge Council's office, and there's a lot of thoughtful people who are devoting a lot of energy to that. But to answer the question, I think it is guaranteed that there will be litigation. But I think that, the Supreme Court has set down markers that can absolutely be navigated in terms of creating a system that truly serves all Vermonters. And, I think, Representative Conlon talked about this and others in the call. I mean, at the ACLU, we are not encouraging and would not suggest that anyone try to target any religious institution or religious actor on the basis of their faith or their activity. I mean, I think, as folks of this call have talked about, what Carson v. Makin has done, I think, is provide the legislature and the state an opportunity to look at the system as it currently exists and say, given the fact that the landscape is changing, does the status quo truly serve all Vermonters, regardless of who they are, where they live, what their parents do, how they express their gender, all the things and all the characteristics that we care about? And this is truly an opportunity to look at that system top to bottom. And it's not really about religious schools versus secular schools. It's about having an education system that's truly equitable. And I think that Carson v. Makin, clearly sets up very clear guardrails about sort of what states can do and what can't they do. But I see the sort of the mandate and the sort of the sort of moral imperative of this moment as being much, much broader and not really having anything to do with religious schools at all. And I think that in some ways that's what this opinion on Friday is talking about a little bit. I mean, I think it was a very narrow posture before the Vermont Supreme Court, but I think the court was as clear as it probably could have been in saying, what really matters and sort of what the real constitutional imperative is equitable education. And the legislature has a lot of flexibility to have sort of as much political imagination as it wants. But that's a long way of saying I do think there will be litigation. I don't think it's by any means a foregone conclusion that is sort of done in an equitable way that serves sort of all Vermonters, that it wouldn't survive judicial review. But I do think that the Supreme Court is clear that it's taking a very close and exacting look at any sort of government regulation that limits participation on the basis of anything to do with religion. And so I think just, truly taking this opportunity to look at it, not from that angle, but from all the other values that we really care most deeply about. I think the more we veer in that direction, the safer from this Supreme Court any legislation will be.
Thank you for that, Harry. Well, so I want to squeeze in a couple more questions here, and actually the next one is going to go to our legislators. So paraphrasing a few things that I've seen here, but they revolve around concerns from folks that live in tuitioning towns, that those tuition options are going to be removed from them, and that those may actually have some very real implications. Folks in certain towns, it's actually attracting population influx because of that option. And how do you respond to concerns about folks that your bill or your proposal is going to remove that option that is actually good for that town?
I can take a stab at that question. First of all, one of the questions I've gotten repeatedly about S66 is that it allows for the designation of 3 public schools, and why is the number 3 and not a larger number than 3? And part of that, the reason is because it's based on current law, the current designation law, which allows for the designation of 3 schools. As I've said to other people, I wouldn't mind if we expanded that number to more than 3, as long as those were public schools, and that schools could only designate other public schools as their the place where their students could go. In terms of limiting options for people in certain areas of the state. Right now, our system where we have created an increasing number of private schools has actually divested from public education in lots of the parts of our state. So there are fewer and fewer options, public school options in many parts of our state because of our divestment in public schools in many areas of our state. And here, for example, in Addison County, Representative Conlin and Superintendent Burrows and I know extremely well that there are communities across our county that are fighting to keep their public schools open. And the more we have competition and divestment in public education, the less those communities are going to be able to keep their public schools open across the state, not just here in Addison County. So we need to really focus our funding and our attention on maintaining and investing in our public schools so that there is choice for parents in every community in our state to send their students to an equitable, well-funded, and excellent public school.
Thank you. Rebecca Holcomb, I saw your hand up.
Yeah.
Down.
Well, Senator Hardy sort of spoke to this, but I think we all need to take a deep breath and listen to our language, because what we're talking about is this feeling of scarcity and this feeling that we're all competing for holding on to opportunity. And when you look at where population growth has actually happened, particularly through the pandemic, it's in two places with a lot of second homes, and it's in wealthy communities. And I still remember sitting at the agency and we were playing with various measures internally to measure changes in the socioeconomic distribution of the state. What we are seeing statewide is concentration of opportunity and disadvantage, concentration of wealth and concentration of lack of opportunity and disadvantage. And as that happens, the risk is if we aren't thinking about a system that statewide is dedicated and committed, just as our education fund is, to making sure everyone has equitable access to high quality opportunity, just the way our education fund does, there will not be opportunity for kids in some of our communities. And this is one of those times when I think we have to step up and look statewide, think bigger than just our own child, to our community and to our state, and how all of those levels are critical to making sure that we have good schools for kids. Because if we're only focusing on a narrow set of opportunities in one community, what we may find is that you end up having no opportunities at all. What I worry about is that we are turning public education into the same thing we have in childcare. Just this morning, I was talking to a parent about how because there weren't enough childcares in her community, people began to move to Chittenden County to take their kids to childcare. Then there were no longer enough children left to operate a childcare, so the last childcare closed down, creating a childcare desert. When I hear Senator Hardy talk, that is what I'm seeing happening in the context of public education. And that does severely constrain what opportunities that kids have.
Thank you for that. Sort of continuing on the legislative line, may turn over to Representative Conlin. One of the questions that we got was whether or not, this was directed actually towards you, and I think the committee bill, a provision that public funds may not be used to either subsidize private students' tuitions, or that there would be some more financial transparency such that we would know exactly how those public funds are being used at the private schools.
Yeah, thanks. And one thing I should have sort of said at the top of my comments is that, our committee bill does a fair amount. Does it do it all? No. I would really like to look at it as maybe step one. And there's definitely strong interest on the education committee to start delving into questions about financial transparency. To the point about public dollars subsidizing tuition, we had one small independent school come to the committee and testify, and we asked how they built their budget. And what they said was, well, we look at how many publicly tuition students we have, multiply it times the tuition, and then build our budget backwards that way, which on the face of it sounds fine, but they also had private pay students whose tuition they were subsidizing. And so that makes you wonder, where is that money coming from to subsidize those private pay students? we have had a short window of time. So at the moment, the bill only contains an attestation by an independent school that practice is not happening. I think that's something we will look into deeper as we start looking into financial transparency.
Maybe if I could just dig into that a little bit more. Have there been any concerns expressed about sort of essentially maintaining sort of a two-stream system here? One that operates with public funds going to private schools, but without all of the same criteria that are being applied to public schools. Has there been any discussion in committee about that?
Are you regarding financial stuff specifically, or?
I would say just overall, like, when we look at things like
Yeah,
there are a whole
I
host of
understand.
rules and regulations that public schools need to comply with that currently private schools don't.
Right.
And I wondered what the community discussion has been around that.
Yes, I appreciate that. Again, I think that we're looking at step one. I think you're talking about things like education quality standards, teacher licensure, those sorts of requirements. These I think are things that are important to discuss. I think that they have probably significant repercussions and therefore deserve a little more time and a little more airing so that we're not, negatively affecting those kids who are being educated currently. But given that the business model for some of these independent schools are essentially relying on taxpayer dollars, they are all questions worthy of looking into.
Thanks. A couple of questions related to the provisions in both S66 and 258 that sort of outlined what schools would be eligible for public funding and those that weren't, and particularly around sort of the carve out considering the historic academies. I'm wondering if either Senator Hardy or Representative Granning would be willing to comment on those carve out provisions in the bills.
Well, I would say I wouldn't necessarily characterize them as carve outs. Those provisions could apply to any independent or private school. They happen to apply to the 4 independent academies because of their historic place in our public school system, meaning that they have had teachers that are in the public teacher pension system. They were at some point allowed to have teachers in that, meaning that their teachers were treated similarly to public school teachers. Two of them operate public career and technical education centers. They were created by the General Assembly. They were chartered by the General Assembly, similar to what our towns and public school districts are. And they, in fact, were defined in statute as a type of public school up until 1991. So the 3 of the 4 of those apply to each of the 4 academies, but if another school came forward and could prove that they meet 3 of those 4, then they could pass that test as well. So it is meant to be applied across all independent schools. It's just that those 4 have the deeper roots in our public school system and therefore meet 3 of the 4 criteria. Neil, if I may say something else about school funding, since it's a topic near and dear to my heart.
Certainly. Please.
I think it's really important to note just how much time and emphasis the Vermont legislature has put on making sure that our school funding system in Vermont is equitable. We saw significant work after the Brigham decision, which Harry went over a little bit in his presentation. Brigham decision, by the way, generated out of Addison County. And the legislature spent significant amount of time on Act 60 and then again on Act 68 to make sure that our funding system was an all-in equitable funding system and that no school and no community would be left behind because of the property values in that town. And it's a system that is incredibly unique to Vermont. And then this recently, last year we passed another bill that radically improves the equity of the way that we spend those dollars to ensure that the funding is that school districts that have a significant number of students who are living in poverty, or students who are ESL students, or students in very, very small rural schools would have access to their revenues that would be able to provide them with an equitable education. And we spent a significant number of years making sure that we were looking at equity from both the side of revenue and expenses. And this is a value that Vermont places in its education. We have, I will argue, the most equitable funding system in the country for public schools. And many of us have worked hard to make sure that that is the case over multiple generations of school leaders and legislators. And when you put into the mix the tuition system for independent schools, it actually decreases the equity in our system. And we struggled with this on the committee that was looking at the pupil weighting study and how to implement improvements to our funding system. How do you account for the fact that the independent school tuition program creates inequity in the system, in the funding system of schools? And I think Representative Conlon alluded to this, in that some of these private schools are using public tuition dollars to fund private pay students. And that creates inequity in the public funding system that we have worked so hard to perfect to the extent possible. So it really is against our tradition of ensuring equity, and not just our tradition and our value, but our constitutional edict to make sure that we do so.
Thank you. I want to recognize that we are just over the top of the hour. We said we would finish by 5 o'clock, but I want to just provide one last moment. So for the folks that are in attendance tonight, we're talking primarily school board members, superintendents, and maybe particular to our legislators. What should these folks be doing as this work continues? What type of engagement would be helpful from school board members, from superintendents, as far as our legislators are concerned, or even if Harry has some suggestions? How do we stay engaged moving forward?
I'd like to start here, if that's okay. I just want to be very clear with everyone that we've presented these as two options, but the legislature is moving on Chair Conlon's bill, on the Ed Committee's bill. That's the one that is moving forward right now. So there were two options on the table, or multiple options on the table. These are the two we were talking about today, and the Ed Committee's bill is the one that is moving forward. So I would focus everybody on that, and we need to support it as it is. None of us will say it's a perfect bill, but it is the bill that starts the conversation. It's the bill that gets us moving forward toward creating a more equitable, more understandable, more transparent system of education in Vermont. And so what I would say is, everybody that write a letter in support to your representative, to your senator. Please move the bill forward. Please don't let this bill get eroded. It is nibbling at the edges of making a really positive change, but it is just the beginning. We need to do more. So please, even though it is not the perfect bill that will fix everything, we need support to move this bill forward.
Thank you. Anyone else?
I
Yes,
just
please.
wanted to follow by saying, I know for superintendents, we've been engaged in this with the Equity Alliance, and that's going to be really important that we continue, both as a state organization and locally. We continue, not just, sending letters to legislators is huge and important. We also need to be doing the work in our community so that the people that we're working with, who maybe don't understand the implications of this, do understand that. So thinking about ways to engage community, to engage conversation around this, along with the political work is really critical. I know in my own experience, I've been having this conversation with many people, and there's a lot of misunderstanding around this. And of course, when you get lobbying groups going head on at this issue, that's what happens. And we need to speak truth to this and help people understand there are real impacts to this, and we have to act.
I guess I would just add, and I appreciate the comments that everybody made and agree with them. The sort of the debate that is going to happen this week is going to be about enrollment, and enrollment that is non-discriminatory, and that space and supporting the philosophy that if you want to accept publicly paid tuition dollared students, you don't get to pick and choose which ones you accept. That's going to be the big debate, and that's what's going to really need the support of folks out there.
Okay. With that, I think that we're going to wrap it up. I know we're like 5 over the hour. You know, and that this, as you had all mentioned, this is probably not the last bit of this conversation as we move forward. I want to thank all the attendees that we had show up today, but I also want to thank my panelists, representatives Conlin, Granning, Holcomb. Thank you so much. Senator Hardy, thank you. Attorney Stark, Superintendent Burrows. Thank you everyone that participated in this. I'm sure that's not the last conversation that we will have on this topic, but I appreciate everyone's input. Thank you all.
Thanks,
Thank
everyone.
you.